Thank you. This is such a great honor to be here and a pleasure to be here. And I've looked around the city today and I cannot believe I haven't been here until now. So beautiful. And you're so fortunate to spend your school years in this beautiful town. So I'm excited to talk about copyright and Gen AI. This is a topic that I'm studying over the past couple of years. And I am particularly excited since we looked through the list of people, and I understand that in the audience, some people are of legal background, some of more scientific or engineering background from information systems or data science. And so I'll try to address both audiences. As some of the research to which this talk relates to is joint research with a team that we have in our lab of lawyers and computer scientists. So basically, just to give you a spoiler for the Gen AI challenge of copyright, the bottom line of this talk and our approach to Gen AI in the context of copyright law is to actually not only look at the challenges brought by this technologies that is disrupting copyright law as it disrupts a lot of other disciplines in law, but also to look at the opportunities that it creates for the legal discipline in general, but more particularly to in the context of copyright law. And I'd like, what I would do is to try and demonstrate both. And so just to start from the beginning, and so we are, I don't need to probably tell this audience about the hype around generative AI, or AI in general, and how disruptive this technology is, especially for lawyers that have to sort of address some of these changes, not just in legal tech, like in our own discipline, but also in responding to the changes in other disciplines, in the finance, in medicine, in transportation, and climate change. The uses of AI in all of these disciplines is transforming the practice in those areas and requires some legal response and legal adjustment. But before we dig into some of the challenges in the context of copyright law, I'd just like to define more precisely what I mean by Gen AI. And the reason is that a lot of what we are seeing, especially in legal literature, actually relates to machine learning. And machine learning of the older generation of 5 years ago, maybe, where a lot of systems, were trained on label data, either supervised or unsupervised, to create a model, and then using the model for classification or for prediction or for any type of these functions. When we talk about generative AI, we're actually talking about something that is taking AI to the next level, and this is foundation models that are actually trained on a general task, trained by terabytes of data, actually not labeled. One can say that large language models are being trained on labeled data to the extent that the language itself is labeled just by the order of the words that we are using. So one word after the other creates some sort of labeling, enabling the training of model. But what is characterizing these foundation models are that they are general purpose. They are not trained for a particular task in a particular area. They could be fine-tuned for this particular task. And again, when we look at when we zoom out from copyright law for a second and just look at the challenge that this creates for law, if we need to go back to foundation model for the things that are generated by these models after they've been fine-tuned to, I don't know, identify cancer or to predict some risks in the financial sector, that creates a challenge of a different type. Another issue is the issue of generative AI, these systems that are enabling not just the Q&A, the question and answer, the prediction or the classification, but also enable some exchange and engagement with these models in the format of a prompt that can generate some new content. All of you, I'm sure, using ChatGPT for this, right? Or for any of you is using, it's like the vice provost not to look now. Any of you is using ChatGPT for your written assignments, for your papers? All of us, right? For using Midjourney or other generative models for preparing our slides, for preparing our videos, and all of that, right? GPT-4 now. If we are programmers, right, we worry about our jobs. Let me just, my son is studying computer science, and when he's as a second year, one of his friends that is a first year asked him just recently, how did you program without Copilot? As if this is like the only way to write a program, but this is something that, and this is like a year ago. And of course, using this for videos, the output of these models can actually win prizes in the context of art, like art competitions. It is displayed on the front page of magazines. And all of this is creating a major disruption for copyright law. And the reason is that copyright law is more than 300 years law that was actually developed with the development of a different technologies, the technology of the printing press. And the rationale for this law was, and you will excuse me for sort of relying on the more common law, British, but mostly American perception of copyright law, but I will also address some of the concerns related to copyright law in civil law countries. But basically, our assumption for copyright law, and that is a reason that we adopted copyright law, was that in order to incentivize authors so that they continue to invest in writing, or more precisely, that someone will invest in producing their writing, publishing their writing, which requires a lot of investment. We need to provide them with a set of exclusive rights that would enable them to extract some rewards for their investment, for the time they spend on this, for the investment they made in turning their manuscript into a book, or turning an idea of a film into a production that required some major investment. So what are the challenges, right? I mean, I promised you to look at the opportunities, but I do want to say a few words about the challenges that copyright law is facing, and why is it that generative models are challenging copyright law. So the first challenge, or the first disruption, is related to authorship, right? To the question of authorship. And a lot of the questions that I'm sure that you have been exposed to this type of literature and conversations, a lot of debate that we are seeing these days is around the question of whether works that are created by GenAI are original works of authorship that are worthy of protection. And the reason this is confusing is because the output looks like original works or creative works. It looks exactly the same. And the question is whether something created by these models or supported by these models is also worthy of protection. So again, I apologize for using American law just as a basis, but originality is actually a pre-requirement for any original work of authorship to be protected everywhere around the world. This is also part not just of national laws, for those of you not lawyers, but also of international law, international treaties. For the work to be protected under copyright law, it has to be original. Now the question is, what is an original work of authorship, and how do we translate the standard for originality that was tailored for human beings into the context of generative models? Where is originality arising in this context? And the dilemma is that if it is a copyrightable work, if it is an original work of authorship, it could be protected. A secondary question would be, who is the author of that work? But first of all, it could be protected, and if it is protected, it is not in the public domain. If it's not copyrightable, it's in the public domain, meaning, for those of you who haven't taken intellectual property law, it could be used by all for free without requiring anyone to request the consent of the owner before any of these, any such use. By the way, how many people have a background in copyright or intellectual property? Okay, so not everyone. All right. And so, yeah, so I'll try to sort of level it up. And so this is not the first time it happens in copyright law. I told you, copyright law is more than 300 years old. And we actually faced that problem during the 19th century when we had cameras that we are all using now with our phone, right, are actually an instrument by which you can create works, some of which are works of authorship and some are not. And the same debates that we are hearing today about GenAI, or similar debates, we've heard about these cameras. And this is like this case that was decided by the United States Supreme Court, as you can see, during the 19th century, was focused on a particular photograph of Oscar Wilde, of all people. And he is sitting in a studio, and this photograph was copied by the defendant, arguing that this is just Oscar Wilde, it's not a work of authorship, and someone has taken a picture, and this does not make it a work of authorship because it is produced mechanically by a camera. So the question was whether, first of all, this is just an output of a mechanical process, like GenAI, right? That is the same arguments that we are hearing nowadays regarding GenAI. This is just the product of someone using Copilot, someone using ChatGPT. And the second issue related to this picture was also, this is just a reproduction of nature. That's the way that Oscar Wilde looks. And so if someone is copying this, is not copying any protected work, but just something that is in the public domain, belongs to no one. No one actually has copyright in the way they look. And so Supreme Court in that case actually decided that the photograph was protected. And it's really interesting and important for our discussion now to understand why, and that has still remained the rule related to originality in American copyright law. And so first reason was that that picture the Supreme Court of the United States held was the product of an intellectual investment by the author. It wasn't just there, but it was actually the byproduct of some intellectual effort, not just labor. It's actually reflected some important choices. And the choices were made here in the composition of asking Oscar Wilde to sit in a particular way, selecting the background, selecting the light and shade, selecting, like this photographer that is now taking my picture, right? You said she has to decide, right? What would be the right angle? You know, what does she want to express, or what does she want to focus on or emphasize, right? All these choices are original choices, the byproduct of intellectual investment that are actually protected as work of authorship under copyright law. If that is the reason for protection, or that is protection would apply to these choices, then we all also know who the author is. The author would be the originator of these choices, the one who makes these selections, and the one who is actually causing, or the effective cause of the work of authorship that is reflecting these choices. So what about this selfie? This is the digital era. Before Gen AI, it was still difficult to decide whether this is original, and if it is an original work of authorship, who is the author here? Most of you look to me too young to remember that 10 years ago, Ellen DeGeneres was the host of the Oscar ceremony. And she actually went, in the middle of that ceremony, she's like taking the steps down, and she joined the audience, and she says, "Let's take a selfie," okay? So she's standing like this, and because she is little, she asked Bradley Cooper to actually hold the camera for her. Now, who is the author of this? Who is making these intellectual choices for which we call a picture like this original? Now, this was like millions of dollars worth of a picture, right? Because it was famous, it was sold to many outlets. And of course, here we can see that sometimes in the creative process, there are lots of parties that are involved. And some of them will just be the long arm of someone else, just like receiving commands. Or like when you take a picture, you don't say, "My camera is the author," right? You're making the picture, right? But here we have someone that conceived the idea and someone that was actually executing the idea. And sometimes both of them will be considered authors, and sometimes we will say that one is actually subject to the other's will. That is, the originality belongs to those who conceived the original work of authorship. Now think of this story that I'm sure that you've seen or remember when you were Little Prince. It's actually worthy of reading when you're older as well, even if you don't have little kids. And for those of you who haven't read the book or don't remember, Little Prince have this conversation with the pilot. The pilot is asking, so the Little Prince is asking the pilot, draw me a ship. By the way, that is what we are asking generative models to do, right? So we say, draw me a ship. Write me the written assignment for my course, right? Write me a computer program. And now here, the pilot is drawing the ship, but the first ship is too old, and the other is too tired. And eventually, the pilot is just drawing this box. And Little Prince asked, where is the ship? And the pilot said, it's inside the box. And then Little Prince says, oh, this is a great ship. Okay, so he's satisfied. And so sometimes in originality, and that is true for many copyright disputes, sometimes we would say the originator, the author, is the one who actually recognized something as a work of art, right? When you think about modern art, for instance, someone that is taking a used shoe and put it in the museum, and you go there and people are saying, oh, this is like very interesting. For the artist was actually selecting something, wanted to convey a message, and recognize something as a work of art. And to that extent, again, if you think of Gen AI and the way in which we interact with these generative models, at one point, we're saying, this is it, right? We have one prompt, we get a response, and we say, now, I want this more in the style of Picasso, or I want this more funny, right? And you sort of have some iteration with the model until you get the results that you want. Sometimes that could be sufficient in order to acquire originality in the final product. And so the debates related to generative models are related to some extent, or also about whether these are supportive tools. That is true, by the way, not just in copyright law, but also when we address issues like tort liability. So the question is whether these are supporting tools that help someone make a decision, or that help someone create their own work, like the long arm of Bradley Cooper, or whether these systems are creative in and of themselves or contribute something that actually is more creative than the user bring to the table to this type of interaction. Because with tools, we know that we all use tools. I mean, I gave you an example of the camera, but all of us are using brushes, and we use word processors. And the question is, what's the difference, right? So now we use Gen AI, and it draws upon more information. Maybe it's quicker, maybe it's more efficient. But the question is whether this is creative in and of itself in a way that actually reduce the type of creativity that a user brings to the table. When we think about this, I'm sure that many of you have heard of this case where actually animals' creativity was brought to a court in the United States, and that started with a legal dispute in copyright law. I'm sure that those of you who don't come from a legal background and come from information science ask themselves, what are these lawyers are doing? But here is how this legal dispute actually evolved. It was this very innovative photographer, again, that was taking pictures of chimpanzees. And the way he did that was that he spread these cameras in where the pictures were taken, and some of these chimpanzees started to take pictures all by themselves. Wikipedians actually wanted to use these pictures in order to put it on an entry related to this type of animal. And Slater, the photographer, actually sued them for copyright infringement. That actually created a reaction by animals' rights organization that actually brought a lawsuit on behalf of the chimpanzee Naruto that went all the way to the Court of Appeal of the Ninth Circuit in California in the United States. And the court held that actually in order to be an agent of copyright, to own copyright, to be considered an author under copyright law, you have to be a human being. And so that actually also was consistent with the holding of the United States Supreme Court office not refusing to recognize animals' rights. And that didn't stop in animals' rights. So last year, the US Copyright Office in the United States, in order to be entitled to some of the copyright protections, actually, if you want to bring a lawsuit for damages in a US court, you have to register a copyright. This is not a condition for protection, but it is a condition for entertaining some rights under American copyright law. The US Copyright Office actually refused to register this very elaborated picture that I've shown you before that actually won a prize, an artistic prize. And what was really interesting about this picture is that it was a result of 600 prompts. So it was not just someone giving a prompt and get a result. It was 600 prompts through repetitive iterations. So like the one that we've seen with the Little Prince, now you have with Gen AI, you write a prompt, you're not happy with what you get, and now you make it more precise, you get a result, and then you improve it 600 times. Still, the Copyright Office refused to register it. For those of you interested, it's very interesting opinion that they actually established a special board to decide this. And also finding that the prompts themselves could be copyrighted. Such might be copyrighted if they're sufficiently original, like a computer program if you want. These are instructions of how to actually produce a painting of that sort. But in general, the court said human creation could be that is created through interaction with Gen AI, might be copyrightable to the extent that it is human. So maybe creating a first draft of your written assignment by ChatGPT, and then creating your own paper and submitting it, that would actually make it not just through your professors, but maybe also through the Copyright Office to register copyright for it. Okay, enough on the first challenge, and that is the authorship challenge or the originality challenge, but just to say something about the normative aspect of it. If we started with the incentives paradigm, that was actually assuming that we have to provide some exclusive rights to authors in order to preserve incentives. The question is whether we still need that in the era of what my late colleague, Dan Burke, called cheap creativity, when it's so easy to generate a book, a film, a computer program. Maybe we don't need that type of incentives 70 years after death of the author in order to actually stimulate that. Another misfit is also with the natural right approach that is more common in Europe, where we actually protect against copying because it actually reflects some communicative act on behalf of the author. And here, some literature, some scholars are actually arguing that to the extent that the copying or the copyright does not actually involve any personal speech by someone, by a human being, then maybe copyright law should not be triggered. Let me just move to the second disruption that I want to discuss briefly, and then move to our talk a little bit about our own research in this area and how we propose to harness the capabilities of Gen AI in order to inform legal decision making. And so the second disruption in copyright relates to infringement. And here we know that you can, so this is Starry Night by Van Gogh, and you can create your own picture that is in the style of Van Gogh, and the question is, and looks somewhat similar, but not identical, right, to this Starry Night. Starry Night is no longer protected under copyright law, but still, if it was under protection, the question would be whether that would be an infringement. For those of you without any copyright background, let me just recap what copyright law is all about. So we have liability for copyright infringement if someone is exercising my exclusive rights, especially the exclusive right to reproduce my work if I'm the copyright owner, or to create, so this is just like copying or doing something that is very, very similar to my work, or create a derivative work that is a work that is based on my original work. Like I'm the Disney Studios in California, and someone is taking Mickey Mouse and create now, not, like little dolls or like a game that is based on Mickey Mouse. So that would be a derivative work. That is a copyright infringement unless it is authorized by law. And in law, we have some limitation and exceptions in Europe. In the United States, the main limitation, there are also some listed limitation and exceptions. So for particular uses, you can actually make use without authorization of the copyright owner. And in the United States, we call it fair use. Okay, coming back again to generative models. So we have this model. So this is a machine that is generating our new content. And that involves a lot of copyrighted materials on both sides. On the left, you see the content, copyrighted works that are being used as input to train these models. I've said before that these models are being trained on terabytes of data, like the entire internet. It's our pictures, it's our postings, it's a video that we are uploading to Google, to YouTube, it's text, it's old books and new books. A lot of materials, many of them are still copyrighted. On the right side, we sometimes have some content that is very similar to a work. And so just to give you an example, the recent lawsuit of New York Times versus OpenAI is actually making both claims. They claim first that OpenAI has trained its models on copyrighted articles that belong to the New York Times. At the same time, they also claim that sometimes when you use ChatGPT or GPT-4, you can actually generate articles that are identical to the articles that are copyrighted for the New York Times. So these are two different claims, and let's just run through them very quickly. We have dozens of lawsuits like this, both in Europe and in the US. Many of them are class actions of authors that are bringing these lawsuits against the developers of these models. All of these models, Midjourney, OpenAI, Gemini, all of them are involved in some of these lawsuits. This is a great website that is actually keeping record of all of these lawsuits And what we see actually coming out of courts is on the input side, on whether using works for training is a copyright infringement. We see so far that in preliminary decisions, judges are reluctant to actually hold that there is a copyright infringement. They say, okay, so the model, the large language model of OpenAI, GPT-4, was trained on your book. Okay. They did that on millions of other books, and they actually only extracted the structure of language rather than copying the actual story in the book. And that, under American law, would be considered fair use. Under other laws, might be considered a permissible use. And so in copyright law, we sort of assume that you can make use of works, for instance, in order to learn, in order to understand, to learn how to draw, to learn how to write, to learn how to read, to learn how to create computer programs. And the question is whether we can do the same in the Gen AI environment. With respect to input, we have many scholars. This is an example of Mark Lemley, but you see a lot of literature supporting either the claim that using works in the training of models is not a copyright infringement, it's not a reproduction at all, or that it is exempted under exceptions and limitations, that it is considered fair use. Israel, by the way, was one of the first countries to actually publish an opinion by the Ministry of Justice saying that under Israeli law that would be considered fair use. But that is only about using materials for training models. What about the output? What if we get something in the output that is very similar to the training materials? So you have this mob dog, right? And it looks very much like these mobs, like all of these dogs. And often in these lawsuits, and that's what we hear, some of these defendants claiming, the fact that there is similarity between the output and the input relates to facts like color, like the size, like the way dogs like this look, that are not protected by copyright law. So the question is, how do we differentiate between the two? And that is basically what our own research was all about. The reason we were studying this is because if you come to a conclusion that any similarity between the output and the input means copyright infringement, you may end up in situations where you are going to protect things that we normally don't protect in copyright law, like facts, like the way Oscar Wilde look, or the way all of us look, that a nose is always hopefully between two eyes, right? That the hair is here, that a necklace is here around the neck, and earrings are on the ears, right? All of these are facts. And all of these are what we consider IDs, right, or generic characteristics that are normally not protected by copyright law. In fact, in copyright law, there is a relationship between how generic something is, that is so common, everyone is using it, and how and the strengths of copyright protection. And so we don't protect general themes that are ingrained in culture. Romeo and Juliet were protected when Shakespeare actually wrote this, but the same scene is part of every romantic story now, right? And so we will consider this too generic to protect by copyright law. And you all know now why. Because I cannot prove it is original. It is not originated with me. It's something that I've taken from what is common that everyone knows. The same goes to programming standards. And so when in lawsuits that were brought against Copilot, when people were saying, hey, look, my program looks exactly like what you generate from Copilot. That is right. But maybe it is very similar because it applies the same programming standards and not because it's a copyright infringement. And there are plenty of things like this that are generic, like artistic styles, like stock characteristics, like characters like Superman, superheroes, Superman itself, the way they dress and look, they are protected, but not every superhero is protected at the seam. Common harmonics or musical arrangements, whatever is common and generic is not protected. And so let me just conclude by saying a few things about our own research. What we were trying to do is actually to use the system itself, models, in order to measure whether something is generic or not. Because if it's generic, it should be excluded. The fact that it's generic means that you can copy it and it's not a copyright infringement. And so what we did was actually relying on the way in which models are working. So models are learning how to, from a red car and a blue car and a red bus, what a red car look like, what a blue car look like, and what a red bus look like. But they can also draw a blue bus. But it turned out that there is a relationship between what's in the training data and what's in the output. So it could create something that hasn't been in the training data. But statistically, if you have like images of only 2 items in the input, in the training, there are more likely to be 2 items in the output. There could be some 3 items and 1 item, but they're going to be more 2 items than 1 or 3. And so we were relying on this distribution, right? What's in the head we will consider generic because it appeared a lot in the training data that trained on all the internet. That means that if it reflects our culture, that is what commonplace or widespread. If it is more in the long tail, then it is less generic. The more further it is in the long tail, maybe it could be considered original. And so we were using for this a methodology that is called in painting. And so we took The Son of Man by Magritte, right? And we were trying to force the model to actually generate it. And so we are taking only the face out. What do you think we will get in the output based on what I was just describing? What would a generic model will just like produce based on the fact that it is more likely to produce things that it has seen a lot? Now, The Son of Man is very famous, right? All of you know this painting. But what we've seen is that you get face. You get face because there are more pictures, even with clouds and a suit and the same hat. When you look at terabytes of data, the model is more likely to provide face.
Is this the face of Donald Trump?
I don't know, but this is interesting. Could be. Could be. Actually, the most famous, we were actually running this on Barack Obama, just last year. We didn't know that the president would have this comeback. But you see more generic, this is, right? And so what is generic is a face. That means that the apple, instead of a face, is rare and not generic and more original. And so therefore, if you can actually use this in order to define infringement a little bit differently. It is only infringing if it memorizes against the natural bias of the data, right? And so you can use this methodology in order to study, to exclude generic ideas, to say all of these are not protected, and therefore, if there is similarity about, these, just the hat, the suit, the clouds around, these are generic and not protected. If there is similarity about the apple, yes, this is a copyright infringement. You can also use, and I will not have time to discuss this, similar methodologies in order to quantify originality. I think that we have a paper that is actually describing it. This is an interesting exercise just because it could be useful for legal decision making. It could help authors actually determine whether what they create is generic, everyone is writing like this, or is original. It can help inform businesses that want to know whether it's worthy for me to pay you or whether I can just generate it all by myself. And it could also help Copyright Office and court decide these cases and determine whether there is infringement, copying that is prohibited by copyright law, or whether this is something that should be permissible or fair use. So just to conclude, it's interesting, the idea-expression dichotomy is very famous in copyright law. These are American judges related to it, but I bet that I could have found some civil law judges also reflect on the fact that it's very, very difficult to distinguish between idea that is common and generic and original expression that is protected. But, and it was always difficult to actually predict that and decide this and reduce it into rules. And now maybe with AI, we can do that more easily. So future is not as grim as it's sometimes described on Gen AI. There are lots of new opportunities. And if you want to learn more, here are some references to our papers, and I'd love to hear your feedback on this. Thank you.